list of demands that they've put to the Rome Statute that they want to be amended. Your thoughts on this?
On my view, there is two sides of this news. First of all, it's very good news, in fact, that shows that Africa finally is ready to defend its sovereignty. And Africa is coming with a common position. That is the real strength of Africa, and this is a really good side of the news. But I feel that there is something not very good in this decision, because to suggest a certain demands, or how many mass media call it threats, it shows that the African Union is still considering ICC as an institution with good intentions, but with bad implementation. I think it's a big mistake. In my opinion, ICC is a very bad idea, which is very nicely implemented. And thus it is not practicable to try to reform ICC. So that is a kind of a bad side of the news. What is really good is the reference of African Union decision to the speeding up process of the creation of new African Union Court. But it is again, there is one danger. Because if Africa withdraw from ICC, it still could make a mistake by making its own ICC. And this is a danger, just to take a model, the Western model of ICC, and impose it on African court. And I think that Africa has a completely different approach in justice. If Western model of justice is retributive and the main aim is repression, the African traditional approach to justice is a restorative approach with the main aim to restore peace and reconciliation. So I very hope that the new African court will not copy the model created by ICC and the Western power, but create a really African court, which will not only called African, but to establish the African model in its essence.
Professor, a huge blow to the ICC of late, with the number of its prosecutions not coming through due to a lack of evidence, and of course the narrative, which could be true in your case, that it's an institution that has been set up and largely viewed as an instrument to make African leaders pliable to the will of the Western nations. The trial of Laurent Gbagbo began last week. We spoke about this with you as well last week. But just looking at the bigger picture, there's a lot of African countries that are still liable to the ICC with all the court cases that it is looking at. How do you think this will affect all the court cases that are in the ICC right now?
Yes, you are right. Those cases which was already initiated will still be in force. So even if African states will decide to withdraw now, many cases will continue, and this is really a big problem, because it will change the situation drastically when the states must be obliged to implement orders of the court, which the state is not a member anymore. So it will be really unique situation. But I think while Africa has a common position, it still could found any decisions, because by the end of the day, it's the states which creates international law. International law is not something like that fallen from the skies. It's norms created by the states, which voluntarily accept certain obligations on them.
Just going back to the cases we're talking about just now, Professor, perhaps you could clear this for us. With the formation of the African Court of Human Rights and Justice that all the leaders have agreed to speed up on, does this mean that it now has the right to try its own cases, meaning that all the cases that are with the ICC right now can be recalled back to the African courts and they can try them themselves? Or is this a done deal with the cases that are at the ICC already?
It's up to the countries to decide this. For the moment, there is a principle of complementarity, which means that if a certain case could be tried in states, they could not be tried by ICC. But the problem is that ICC is not respecting this principle, and to tell you the truth, some countries also do not respect this principle. Just several days ago, we witnessed another example of violation of this principle when the accused, who was acquitted in ICC, is facing trial in Democratic Republic of the Congo. So what we see now in the context of your question is a total mess, and this is a very unfortunate situation. But I think again. International law is a matter of negotiations. So if African Union be united, it could negotiate any rules it consider as appropriate for them.
Just going back to what the African Union has demanded from the ICC Rome Statute, one of those being that they should give immunity to sitting heads of states and senior government officials. Just now you were talking of how they can take the same ideas from the ICC and implement them to the African court. Doesn't that defeat the whole purpose of the court to try and seek justice for victims? I mean, if the heads of states will be given this immunity, so who is there to try?
Well, I feel a little bit strange to comment the demand that ICC respect the immunity of head of states, because there is nothing in ICC statute that gives this ICC the right to claim that head of states doesn't have immunity. So the existing rule of international law, the customary international law, assure to all head of states immunity. And it was confirmed by the International Court of Justice, the principal judicial organ of the United Nations. So I think that there is a lot of misunderstanding on this matter when some commenters claim that ICC statute dismissed or abolished the immunity of head of states. That's not so. Until we receive the text, because today we are talking for reporting mass media what the African Union said. But after we receive the complete text, it would be clear what was the position of African Union. Probably the African Union asked some corrections to the text of the statute or something else. But until now, there is nothing in ICC statute that gives this court the right to say there is no immunity of head of states anymore. That's not true.
Of course, Professor.